It's been nearly a century since the federal government put strict limits on a tool meant to make gunfire quieter.
If these lawsuits hit, you might never have to register your suppressor or SBR again.
A major legal challenge has been brought against the so-called silencer or suppressor ban.
This all comes after the Trump DOJ recently decided to change their position on suppressors, and they found that these are in fact protected arms.
By eliminating the excise tax on these items, the One Big Beautiful Bill serves as a critical step towards our ultimate goal of dismantling the NFA once and for all.
But this is not the time to let up, it's the time to double down. And the Second Amendment could not be clearer. Our founding fathers could not be more clear.
The federal government just admitted that suppressors are protected by the Second Amendment, and then turned around and said they can still restrict them anyway. What happened next in court is something nobody saw coming, and it could reshape gun rights in America forever. Here's what's going on. There is a case right now that is barreling toward the Supreme Court, and it involves one of the most controversial items regulated under the National Firearms Act, suppressors. And the reason this case matters so much isn't just because of suppressors themselves. It's because of the legal theory the courts are using to justify keeping the NFA intact. A theory that, if it holds up, could give the government a blueprint to restrict virtually any firearm or accessory it wants. And that should concern every single gun owner in this country. Let me walk you through how we got here, because the twists and turns in this case are genuinely wild. The case is called U.S. versus Peterson. It started back in 2022 when federal and state law enforcement officers executed warrants at a man's property down in Louisiana. We're talking ATF agents, roughly 50 officers total, all descending on this guy's location. There were allegations tied to his gun store operations, but the Second Amendment issue at the heart of this case comes down to one single item, a solvent trap that was treated as a suppressor under the NFA. One item. That's what this entire constitutional battle is about. Mr. Peterson moved to dismiss the suppressor charge on Second Amendment grounds. The district court denied that motion, and the case moved up to the Fifth Circuit Court of Appeals.
And while it took away the Tommy gun, that law also put strict limits on a tool meant to make gunfire quieter.
Gun retailers are reporting a surge in the sale of gun silencers since January 4th.
This is a major lawsuit that will have implications rippling throughout the Second Amendment community, including the National Firearms Act.
I'm talking about a real legal path that opened when Congress zeroed out the old NFA tax.
However, the Trump DOJ continues to argue that the NFA's restrictions on suppressors does not violate the Second Amendment.
Reducing the tax to $0 is a step forward, but not the win the people deserve.
Now, the Fifth Circuit is one of the most important appellate courts in the country when it comes to gun rights. And initially, a 3-judge panel sided with the government, which at the time was operating under the Biden administration's Department of Justice. That original panel ruled that suppressors are not arms under the Second Amendment and therefore don't receive any constitutional protection at all. That was a devastating ruling for suppressor rights and for the broader interpretation of the Second Amendment. But then something changed. The Trump administration took over the DOJ, and the new Department of Justice made a stunning pivot. They actually conceded that suppressors are in fact protected arms under the Second Amendment. Think about the significance of that for a moment. The federal government's own lawyers walked into court and said, yes, suppressors are arms, and yes, the Second Amendment covers them. That is a massive shift in the government's legal position, and it forced the Fifth Circuit to withdraw its original opinion entirely. Now here's where things get really interesting, and here's where the concern kicks in. The panel went back to reevaluate the case in light of the DOJ's new position. You might think that if the government itself is saying suppressors are protected arms, the court would strike down the NFA restrictions. But that is not what happened. Instead, the Fifth Circuit issued a brand new ruling that upheld the NFA, but on completely different grounds. And the reasoning they used is what makes this case so dangerous for gun owners across the board. The Fifth Circuit ruled that even if suppressors are constitutionally protected arms, the NFA's regulatory framework survives constitutional scrutiny under the Supreme Court's Bruen decision. Their argument goes like this. The NFA's suppressor regime operates essentially like a shall-issue permit system. You pay the tax, you submit your fingerprints, you pass a background check, you register the item, and as long as you meet the objective criteria, you get approved.
Now, on review, the court denied his motion to dismiss the indictment, and that led Mr. Peterson to appeal to the Fifth Circuit for the first time.
A section in what's been dubbed the Big Beautiful Bill would strip away those restrictions, as gun rights advocates cheering and gun safety groups sounding the alarm.
But, and this is the fight, The feds left the registration process in place.
Taxes and registration requirements for all of those items would be removed under the one big beautiful bill.
The Vice President votes in the affirmative. The bill as amended is passed.
We all know the NFA was nonsense from day one, a relic from nearly a century ago.
The court said that's functionally the same thing as a shall issue concealed carry permit, which Justice Kavanaugh suggested in his Bruen concurrence may be constitutionally permissible. Now, let that sink in for a second, because this is the part that should make every gun owner pay very close attention. The Fifth Circuit just took language from Bruen, a case about concealed carry permits, and applied it to the entire NFA framework. They're saying that as long as the government structures its restrictions around objective criteria, it can regulate even constitutionally protected arms through a permitting process. That is a breathtaking expansion of what Bruen's shall issue language was ever intended to cover. And if that logic stands, it doesn't just affect suppressors, it affects short-barreled rifles, it affects short-barreled shotguns. It could theoretically affect any firearm or accessory the government decides to run through a similar regulatory scheme. Just create an objective permitting process, slap a tax on it, require some paperwork, and suddenly the restriction is constitutional. That is the door this ruling opens.
Translation, the money grab is gone. You won't pay the $200 tax after the effective date.
In 16 of those states, it is a felony, it is a crime, it is contraband, it is illegal to possess suppressors.
The Fifth Circuit 3-judge panel still ruled that the NFA can regulate suppressors since the process operates as a shall issue permit.
With the Fifth Circuit Court of Appeals taking a very unusual step in withdrawing an opinion
about these rights shall not be infringed. The fact that they're taxing these short barrels is an infringement on our Second Amendment rights.
The complaint also goes on and argues that suppressors are, of course, in common use.
After the panel issued this new opinion, Mr. Peterson sought what's called en-banc review, meaning he asked the full Fifth Circuit, all the judges, to rehear the case. The Fifth Circuit denied en-banc review, but they didn't stop there. They went further and issued the mandate, which essentially means the ruling goes into full effect immediately. That's not just a procedural technicality, that has real life-altering consequences for Mr. Peterson personally. Here's why. If the mandate goes into effect, Mr. Peterson could potentially be required to report to prison, even while he's actively seeking Supreme Court review. He told the court explicitly that he intended to take this case to the Supreme Court. He filed an unopposed motion to stay the mandate, meaning to pause it from taking effect while he prepares his petition. And here's the kicker. Even the Trump DOJ did not oppose that stay. The government's own lawyers were fine with pausing the mandate. They recognized the impact it would have on this man's life and liberty. But the Fifth Circuit denied the stay anyway. The order was blunt. It simply said, the unopposed motion to stay issuance of the mandate pending certiorari is denied. No explanation, no reasoning, just denied. The court was willing to let this decision go into full effect and expose a man to prison time even though his case was actively heading to the highest court in the land, and even though the opposing party didn't object to a pause. That tells you something about where at least some of these judges stand.
The proposition that any permit system restricting two-way rights may be allowed as long as it operates objectively.
Under the Supreme Court's current test, the government has to show a historical tradition of similar restrictions.
After all, the National Firearms Act is just a tax scheme. It is literally just a tax.
Proof that you possessed this firearm before the ban took effect. Now that language has been removed entirely from the Senate bill.
If an arm or something that's necessarily implicated with the use of arms is in common use, it is protected.
Now, fortunately, the story doesn't end there. The district court, the lower trial court, stepped in and allowed Mr. Peterson to remain free on bond while he prepares his Supreme Court petition. So he will remain a free man during this process, which is the right outcome. But the Fifth Circuit's refusal to pause its own mandate is significant. It sends a signal about how seriously, or rather how unseriously, that court took the stakes involved for this individual and for the broader constitutional questions at play. So where does this leave us right now? Mr. Peterson has until approximately March 9th to file his petition for certiorari with the Supreme Court. That means in just a matter of weeks, a critical suppressor and NFA challenge will land on the desks of the 9 justices. and this petition is different from previous attempts to get the court to weigh in on suppressors or the NFA. This one is built directly around Bruen. It asks the Supreme Court to address whether the shall issue permit language from Bruen can be stretched to cover regulatory schemes like the NFA. It forces the court to clarify the boundaries of its own precedent, and the stakes could not be higher. For Mr. Peterson personally, a loss means serious prison time. For the rest of us, a loss, or even a refusal by the court to hear the case, means the Fifth Circuit's framework stands. And that framework says the government can restrict any protected arm as long as it wraps those restrictions in the clothing of an objective permitting system. That has implications far beyond suppressors. It could reshape how courts evaluate firearms regulations nationwide.
No more $200 tax stamp on suppressors and short-barreled rifles. Yeah, you heard that right.
One of them, which is the largest downside, is the NFA still stands, and the possibility of a new...
Still doesn't make it good enough. I mean, we're still talking about bans on some of the most popular and commonly owned firearms in the country. Mario is...
He argues that the panel wrongfully equated the NFA's taxation scheme for suppressors to something like a shall issue CCW licensing scheme.
On the other hand, if the Supreme Court takes this case and rules that the NFA cannot simply be rebranded as a shall issue permit to survive constitutional challenge, that would be an earthquake in Second Amendment law. It would call into question the entire structure of the NFA and could open the door to further challenges against restrictions on suppressors, short-barreled rifles, and other items that millions of Americans want legal access to without the current bureaucratic and financial hurdles. This is one of those moments where the legal landscape is genuinely hanging in the balance. The next few weeks will determine whether the Supreme Court steps in or lets the Fifth Circuit's reasoning stand unchallenged. In either way, the outcome will ripple through Second Amendment jurisprudence for years, possibly decades to come. So keep your eyes on this case. As soon as the petition is filed and as soon as there are any developments from the Supreme Court, we will break it all down right here. This fight is far from over, and what happens next could define the future of firearms freedom in this country. That's it for today, folks. See you in the next video.